I asked the court to recuse. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure the court put on him.
Ooh, that's going to be insane.
I just can't imagine how that's fair to Mr. Williams.
Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay?
Day 94 of the Young Thug YSL RICO trial was painful. The judge officially responds to Brian Steele's motion to recuse him. Then they argue over the Lil Woody interviews being shown to the jury. Yet today's video is extremely short because nothing really happened besides the beginning where the judge responds. The rest of the day, literally nothing happened. Complete waste of time. Hit subscribe. Here we go. First look at Thug on day 94. No jury in today. Brian Steele's got some interesting glasses on right now. The fuck are those? Brian Steele runs marathons, by the way. Doesn't that fit his personality perfectly? So Woody's lawyer, Ms Bumpus, brought this goddamn Avengers of lawyers.
I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? And counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday. When I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay?
Attorney Kayla Bumpus, who represented Kenneth Woody Copeland, filed a motion to quash the show cause hearing scheduled for next week over who leaked the information about the ex parte meeting to defense counsel. So that's the motion the judge is talking about right there, the quash.
And this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which will fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days, first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else, and that is Robinson versus the state, 332 Georgia Appeals at 240-241.
Let's see if he does it.
Threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true. Recusal would be warranted, and that is Dacker versus the state, 300 Georgia, 74-77, 2016. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion, and motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed. In addressing the legal sufficiency of the affidavit, that means was it sworn before a notary is in proper form. I find Mr. Williams and Ms. Bumpus's motions to be, I should say, affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion.
Here we go.
And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions, bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order.
The appellate courts are going to have a field day with this case. It's sad it's going to have to come to that.
I will file that so you can take whatever steps you need to necessarily after that. I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only 3 things I do. And then if I find it to be not sufficient on its face, I go for it. I know
Brian Steele's gonna be pissed about this, dude. The affidavit was bat. In my opinion, it showed the judge had bias towards Mr. Williams. I know a lot of people think that too. I'd say 75% of you guys agree with that as well, that he's shown bias with the way he's yelled at them in front of the jury.
I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. That's where we are at this point in time. Anything else, Mr. Banks?
I understand the court's ruling and will proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be.
Appeal. Holy shit, he just keeps bringing up appeal. Like, appeal is going to be years down the line, and these guys are going to be still in jail. These boys just want a fair trial. That's all.
Ruling for abuse of discretion.
Certainly understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding.
This is separate from the recusal. So he's just talking about the contempt part, not the entire trial for Ms. Bumpus and Woody.
Witness.
I don't believe you. I'm not going to get into any argument. I can't. That's your assertion at this point in time. And like I said, when that is taken up, I'll consider. I also remember I still need to rule on the issue of the motion to quash. So depending upon what I decide to do at that point in time, other things may be right. Okay.
Do you want to hear about the motion to quash, or you want to take
No, not yet, sir. I'm going to take up the motion to quash after we finish the direct of the current witness.
Okay.
And there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady.
We don't believe that that's a bare allegation. We believe that that would be an established fact at the hearing. We also,
but I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your clients.
I mean, he is a witness at the contempt hearing on the 25th, June 25th, in 7 days. The contempt hearing is going to be crazy. Here comes Brian Steele.
I've read Baptiste versus State. I've read all the cases that I believe are applicable, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester Collins, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list, plan on calling the court as a witness in the trial. I've added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland when that day comes, I'm going to ask him about how much pressure, if any, the court put on him.
Ooh, that's going to be insane, dude. Cross-examination of Kenneth Copeland is going to be fireworks. I feel like it's going to come maybe next week if we're lucky, but it might be the first week of July.
And you're going to be the one instructing the jury. I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just even paragraph 12, again, if you didn't, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand how.
Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to
Bro's eating a mint right now.
The recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver's gonna prepare the record. She does that, and like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right.
Now the lawyers in the state are going to argue about the Woody interviews. So now we come back 2.5 hours later, 2.5 hour long break for the state and the defense to discuss things.
And we're working through 16 and 17. So there continues to be a certain...
This. The rest of the day's pointless. Nothing's going on. I'm sorry. I can't do it. The rest of the day is absolutely pointless. The judge is going to let it in. He's going to let whatever the fuck he wants in. So no court tomorrow and Wednesday. And then Thursday, they're not going to have the jury again suddenly. The judge just said they didn't get enough work done. That's what Thugger Daily tweeted out. I say this every video. This trial is an absolute shit show. Please subscribe. Love you guys. Peace out.